Hi, I'm Max Dilendorf, a New York-based attorney and founder of Dilendorf Law Firm. Our firm assists U.S. and global families with estate planning and cross-border structuring. And in today's episode, I want to talk about one of the most critical pieces of any Cook Islands trust structure, and that is selection of the professional trustee company. If you are a U.S. Client exploring offshore planning, understanding the trustee's role and how they are regulated is a critical step. So let's start with the basics. Under the Cook Islands Trustee Companies Act of 2014, every Cook Islands trust must have a licensed trustee that is physically present in the Cook Islands. You can't set up a valid trust without the trustee. And so the trustee becomes the legal owner of the trust assets. They manage those assets according to the terms of your trust agreement, what we call the trust deed. And the trustees are bound by law to act in the best interests of the trust and its beneficiaries who hold the equitable title to the trust assets. These trustees are regulated and licensed by the Cook Islands Financial Supervisory Commission, also known as the FSC, and currently there are only 8 trustee companies licensed in the Cook Islands, and getting those licenses is a serious undertaking. Under the Trustee Companies Act of 2014, any trustee company must have a physical office in the Cook Islands, submit to the Commission its annual financial audits, maintain professional liability insurance, and comply with strict anti-money laundering and counter-terrorism financing rules. These are regulated fiduciary companies with actual office people and accountability. Now, at our firm, we work with several of the leading trustee companies in the Cook Islands. We help our clients select the right trustee based on their objectives, asset profile, and the trust structure. It's also important to understand where the trust assets are held, because the trustee doesn't physically hold your assets. Instead, assets are typically held in a secure, segregated accounts in top-tier banking jurisdictions such as Switzerland or Liechtenstein. Those assets are often held through a limited liability company that's owned by the trust. And so the trustee oversees the structure, but the actual assets sit in the financial institutions. One more thing, when a client establishes a Cook Islands trust, they typically appoint a protector, which is a good idea, and a protector is usually a trusted attorney or a professional advisor who has the authority to remove and replace the trustee if needed. This means you don't lose control, although the trustee has powers as described in the trust agreement. The protector is there to make sure that your wishes are respected in the long term. And so this model gives you the professional oversight, legal protection, and international diversification, as well as the compliance framework that satisfies U.S. reporting requirements. If you're thinking about offshore planning, understanding how the trustees work under the 2014 Act is a critical first step. Thank you for watching. I am Max Dilendorf, and I will see you in the next episode.